Outstanding. This subcommittee will come to order. Good afternoon. Good afternoon, everybody. Not very responsive. All right. We are here today to discuss 12 bills that would benefit veterans and their survivors. These bills would ensure that veterans receive faster, more accurate decisions on their claims for VA benefits from VA Board of Veterans Appeals and the Veterans Benefits Administration, provide veterans with more choices to control how and when their claims are processed by VA, thus building on the Veterans Appeals Improvement and Modernizations Act of 2017, make the VA claims and appeals process more understandable for our veterans and their survivors by providing them with clear updates and instructions. It will decrease the number of unnecessary disability compensation examinations that are causing delays in claims processing, improve access to VA benefits for veterans, spouses after the loss of their loved one, and increase their compensation that survivors are eligible for, and ensure the VA gives equal attention to the needs of our nation's veterans as well as their survivors. I am proud to introduce two bills today. My bill, H.R. 7777, the Veterans Compensation Cost of Living Adjustment Act of 2024 would give a cost of living adjustment to veterans and survivors receiving certain VA benefits. This increase would be the same as what Social Security recipients get. In the face of rampant inflation, this bill is vital for ensuring that our veterans are able to pay their bills and put food on their tables for their families. I appreciate the Ranking Member Pappas for co-leading this important bill. Thank you, sir. H.R. 7919, Veterans Claims Quality Improvement Act of 2024 would ensure that veterans receive accurate and fair decisions on their claims from the VA Board of Veterans Appeals. The board claims to have quality rates of over 90%. However, in November of 2023, the Subcommittee on Oversight hearing revealed that those rates are slightly inflated, and the board's quality control and training programs are ineffective. As a result, each year, thousands of veterans receive board decisions that are filled with legal error. To correct these errors, veterans must appeal those board's decisions to the U.S. Court of Appeals for Veterans Claims, which adds more months or even years of waiting for an accurate final decision on their claims. And we have heard that the board often unnecessarily sends veterans' cases back to VBA instead of actually deciding their claims. This bill would ensure that board leadership and low-performing board judges are held accountable for the errors that the board makes over and over again. Further, robust quality control and adequate training are crucial for ensuring that the board does its job of issuing accurate decisions. This bill would ensure that the board implements effective quality control and training programs. Veterans wait years for a final decision from the board, and each veteran deserves a high-quality decision when they finally get one. I would like to thank Representative Stefanik and Bill Arakis for signing on as co-sponsors to this bill. I look forward to working with Chairman Bost and my colleagues on this subcommittee to advance these important proposals today. Chairman Bost and I have gone through the disability claims process ourselves, and it is the top priority for us to ensure that the process works for every single veteran. I know my colleagues have worked hard on each of these bills to improve the claims process and to increase access to VA benefits for veterans and their survivors. I look forward to discussing these bills on our agenda and hearing from the witnesses who have joined us today. And I now yield to the ranking member for his opening remarks.
Thank you very much, Chairman Luttrell, and I appreciate you holding this hearing today on pending legislation. As we can all tell, there's a lot of pent-up legislating to do in this place, so let's get to it. And I want to say, Mr. Chairman, I appreciate you including so many priorities from our side of the aisle on the agenda today. That's terrific. I want to thank all of our witnesses, both governmental and non, who are attending today. We take your testimony incredibly seriously, and it helps inform the important work that is left ahead of us. With that said, Mr. Chairman, there's a great deal of policy contained in the bills today, and I think we can find common ground on a host of issues. For example, I think it's clear that the Appeals Modernization Act has not moved the needle as far and as fast as the Board of Veterans Appeals and Congress had hoped. I think we also agree that the Veterans Benefits Administration is ordering too many C&P exams, which can have the effect of slowing down claims processing. But, Mr. Chairman, I think where we lack consensus, both in Congress and with stakeholders, is on the scope of those problems and any potential fixes to them. There are a lot of proposals on the agenda today to address these issues, but as we can see from the testimony, there's very little agreement on which solutions are needed, which are not, and which could actually make things even worse. So I worry that because of the aggressive timeline, we'll will be on between this hearing, next week's subcommittee markup, and the full committee markup in May, we may not be able to arrive at the kind of consensus that also passes muster with stakeholders on these key issues. So I urge thoughtfulness and caution as we move ahead, and I humbly suggest that it may be more important to take our time to get the policy right rather than to be fast and risk any unintended consequences. So I thank you for holding this hearing. Look forward to the testimony from our witnesses, and I yield back.
We have got a very full agenda today, so I will be holding everyone to 3 minutes per bill so that we can get through all this morning. We are joined by several of our colleagues, both on and off the committee. That are going to be testifying on their bills that they have co-sponsored. To provide testimony for the bill, let's see, Chairman Bost, is he present? Mr. Duarte, you're recognized, sir.
Thank you, Mr. Chairman, committee. It's an honor to be before you today. Recently, in preparation for this hearing, I had a meeting in my district with veterans groups from all over the Central Valley of California to learn more about the realities of being a veteran, helping veterans around the valley, and what some of their interests and frustrations were. This bill, the Clear Communication for Veterans Act, is H.R. 7186. Is the veterans claims process is broken. Veterans are getting letters from the VA pertaining to their claims. They're lengthy letters, they're confusing letters. They're very hard to decipher and very difficult for the veteran to move forward and know what the course of action to remedy claims disputes or get the services they deserve and they very desperately need in many cases. And the veterans deserve a smooth claims process for VA benefits that they've already fully earned. Right now, the guidance they receive from the VA is so comprehensible that they often abandon pursuing the benefits they deserve, and that's not acceptable. VA's notice letters are critical to ensuring veterans' understanding to how they pursue their claims for the VA benefits that they've earned, and the veterans should not be subjected to letters that are overly complex and confusing. So this is a bipartisan bill, and the Clear Communication for Veterans Act simply asks us to bring in an outside, nonpartisan professional research and development corporation to look through the entire Veterans Claims Processing Act, the veterans' letters, and how these communications go forward, and bring us a professional outside opinion on how these can be better handled. There's no partisan element to this bill. It's very common sense, takes it out of the VA, where they have failed to improve these letters over years. We've charged them with that, as I understand from your committee. And now it's time to move it to the professionals and see if an outside group can help improve these veterans' claims letters. And it's really that simple. And I thank you for that, and I'm open to any questions.
Thank you, sir. Mr. Duarte, give me 1 second, please. We're going to do a round robin. Mr. Duarte, we'll come back to you. Mr. Self, you're recognized, sir.
Thank you, Mr. Chairman. Chairman Luttrell, Ranking Member Pappas, I am pleased to sponsor the Toxic Exposures Examination Improvement Act, which aims to address a significant flaw in the disability compensation claims process. We've been told repeatedly that VA is scheduling too many unnecessary toxic exposure-related disability examinations. These so-called TARA exams are intended to determine whether a veteran's claimed disability is related to toxic exposure. TARA exams are more complicated than regular disability compensation exams. My bill would cut down on unnecessary TARA exams that waste time and resources for both the veterans and VA. It does this in two key ways. First, it proposes that the VA should only obtain a TARA exam when the evidence is insufficient to make a decision on the claim of compensation. Veterans whose disabilities are objectively unrelated to any toxic exposure should not have to attend unnecessary TARA exams. I must emphasize, however, that even if a TARA exam is unnecessary to support a veteran's claim, VA must still get a regular, less complicated disability compensation exam when a veteran's disability might be related to any in-service event other than toxic exposure. Secondly, the bill provides VA clarity by defining entry into the DoD EILER system as any entry indicating toxic exposure. By removing ambiguity stemming from the current lack of definition, which is the problem, we enable the VA to accurately identify veterans who may have been exposed to harmful agents during their service. By saving time and resources for both veterans and the VA, my bill would allow VA to prioritize the needs of those who have served our nation while maintaining the integrity and efficiency of our veterans benefits system. I urge my colleagues to join me in supporting this important piece of legislation, and I yield back the balance of my time. Thank you.
Thank you, Mr. Self. Chairman Ball, sir, you're recognized for 3 minutes.
Thank you, Chairman. Before I would start, if I could, I want to give a shout out to Andrew Tangen, who flew in from my home state of Illinois to testify today, and I want to give that shout out. Well, I want to let you know that I'm proud to have introduced 2 bills on the agenda today. Both bills continue my personal goal to provide veterans with more choices and faster decisions when it comes to their disability compensation benefits. Just like the Veterans Appeals Improvement and Modernization Act of 2017 has done. First, H.R. 7793, the Veterans Appeals Options Expansion Act of 2024, would lock in the date of an incorrect claim form for the purpose of veterans being eligible to receive back payments. Right now, VA does not pay veterans all the way back to the date of their incorrect claim form. Veterans should not have to be punished because it's hard to figure out which VA claim form to use and how to navigate the VA appeals process. Now, my bill would also allow a veteran more time to switch one VA Board of Veterans Appeals docket to another. This is a key fix to improve the appeals process that we've heard firsthand from veterans. Now, my bill would also lock in the date of the veteran's original appeal. The board sends back to the VBA 50% of the veteran's appeals. When a veteran's appeal ends up back at the board, that veteran gets kicked back to the end of the board line. All of this bureaucracy adds years of waiting. Veterans should not be punished because the board could not or would not make a decision on their claim the first go-round. My bill would also guarantee that the board judge who held a hearing will decide a veteran's claim. The judge who best knows a veteran should be the one to issue the decision. Finally, when Congress enacted the AMA, we stated that we intended and expected that the VA would develop robust policies for addressing untimely evidence. 6 years later, VA has not done that. Now, my bill would rightfully force VA to ensure that the board is promptly telling veterans when they have submitted untimely evidence so that they can act on that information. Now, my second bill, H.R. 7917, the Veterans Appeals Efficiency Act of 2024, would ensure that the VA Board of Veterans Appeals issues faster decisions. Right now, even the massive investment that Congress has made in the board, veterans are still waiting 2 to 5 years for a board's decision on their AMA appeals. And there are currently over 200,000 pending appeals before the board. We cannot keep giving millions of dollars to the board to simply hire more staff when the board realizes that it will take years to deplete its inventory at today's rate. We must authorize additional tools and processes for the board to modernize, whether they want to or not. So that it can be issued faster decisions in the veterans' claims. We know that class actions can be powerful tools for processing claims and case effectively. The real world does it every day. Even the Veterans Court recently rose to the challenge and began doing class actions. My bill would authorize the board to decide large groups of veteran appeals, all with similar evidence and themes, at the same time. But we must ensure that this process would work for veterans and for the VA. This is why my bill would require VA to obtain recommendations on how class actions could work at the VA. My bill would also authorize veterans courts to include far more veterans cases in class action before the court. Under current law, the Veterans Court can allow only veterans who have received a board decision to join a class action. Because not a lot of veterans have received a board decision, the court's current class action authority is currently not effective. Also, the board often overlooks key evidence. When that happens, the court sends the entire case back to the board. The court should be requiring the board to quickly address the specific things the board overlooks. Instead, the board is issuing an entirely new decision on the whole case. That's government bureaucracy at its worst. Now, I know from the personal experience how complicated and slow the VA claims appeals process can be. My bill would ensure that the process works for, not against, veterans and their families. I look forward to the discussions on both these proposals, and I would like to thank Representative Stefanik and Bilirakis for co-leading on both of my bills. And with that, I yield back, Mr. Chairman.
Thank you, Chairman Boss. Ms. Hayes, thank you for joining us. You're now recognized.
Thank you, Mr. Chairman. While I do not serve on the House Veterans Affairs Committee, I thank you for allowing me to speak here today. I'm committed to honoring the men and women who serve our country by ensuring veterans and their families can access the benefits they have earned. My district office in Waterbury, Connecticut is the only congressional office in New England to be recognized as a Purple Heart Office of Distinction by the Military Order of the Purple Heart and to be listed on the Purple Heart Trail because of our work to support veterans. My legislation to support veterans has been signed into law by both Democrat and Republican administrations, so I appreciate your consideration today. Today I am here to speak in support of my bill, the Caring for Survivors Act, which would support thousands of military and veteran survivors who feel their current benefits are less than they have earned and have not been adjusted over time. When a service member dies in the line of duty or a veteran dies from service-related injuries, their surviving family members receive a monthly cash payment known as Dependency and Indemnity Compensation, or DIC. The United States has compensated surviving families for the death of their loved ones since the Revolutionary War. Unfortunately, the DIC rate has been minimally adjusted since 1993 and is nearly 12% lower than the rate of other federal survivor programs like the Federal Employee Retirement Systems, or FERS. DIC beneficiaries receive 43% of the current rate given to a totally disabled veteran. Beneficiaries for federal civilian employees can receive up to 55% of the insurance annuity for their deceased loved ones. Also, if a veteran dies because of a non-service-connected injury left him totally disabled for less than 10 years, current DIC law limits the number of survivors who can qualify for these benefits. This provision ignores the years of sacrifice by families who have cared for their disabled veterans, often putting their own lives on hold. My legislation does two things to correct these problems. First, my bill raises DIC to 55% of the rate given to a totally disabled veteran instead of the current rate of 43%. By bringing DIC to a level consistent with other federal survivor programs, survivors will receive an average increase of about $400 per month. Second, my bill reduces the 10-year disability rule to 5 years and allows more survivors to qualify for DIC benefits. This provision expedites DIC support for beneficiaries. This legislation is supported by Tragedy Assistance Programs for Survivors, Gold Star Wives of America, the Military Officers Association of America, Paralyzed Veterans of America, Veterans of Foreign Wars, Disabled American Veterans, and the National Military Family Association. I want to thank you, Chairman Tester and Senator Boozman. I want to thank Chairman Tester and Senator Boozman for their support of this legislation in the Senate. I also want to thank Chairman Luttrell and Ranking Member Pappas for allowing me to speak here today in support of my legislation. I want to take a moment also to recognize the thousands of surviving spouses around the country for their advocacy to make these important and necessary changes. The Caring for Survivors Act recognizes the importance of timely and substantial benefits for survivors, ensuring their families receive the benefits they have earned through their service. I encourage all of my colleagues to support this legislation and move it through committee for not only through committee, but to the floor for consideration and a vote. We must honor the promise we made to our service members, veterans, and survivors that have been left behind. Again, I thank you for allowing me to be here and ask you again to consider this legislation and the impact on the families who are left behind. Thank you. I yield back.
Thank you, Ms. Hayes. We will forego a round of questioning for the members. Any questions may be submitted for the record. In accordance with committee rules, I ask unanimous consent that Representatives Duarte of California be permitted to participate in today's subcommittee hearing. Ms. Hayes, you're welcome to join us as well if you wish. You're now excused. I invite our second panel to the table. You guys ready? That wasn't a loaded question. You guys ready? Okay. Joining us today from the Department of Veterans Affairs, the Honorable Jamie Jaime Arizaga Soto. Did I nail it?
Yes, sir.
Outstanding. Thank you. Chairman of the VA Board of Veterans Appeals. He is accompanied by Ms. Brianna Ogilvie, Assistant Deputy Undersecretary for the Office of Policy and Oversight at the Veterans Benefits Administration. Ms. Jessica Pierce, Assistant Director for Compensation and Service Policy Staff at the VBA. Also joining us from the U.S. Court of Appeals for Veterans Claims is Colonel Tiffany Wagner, Clerk of the Court. I now recognize the ranking member. Who did I forget? Mr. Daniel Shedd, I apologize. I didn't leave you out because you're on the end, I promise. Will all the witnesses please stand and raise your right hand? Do you solemnly swear the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Thank you, and let the record reflect that all witnesses answered in the affirmative. Mr. Chairman, you're now recognized for 5 minutes to present the department's testimony.
Pappas, Congressman Self, and other members of the subcommittee, Congressman Duarte. Thank you for the opportunity to appear before you today. With me today are Brian Ogilvie and Jessica Pierce, both from BBA. Secretary McDonough's mission is to provide more care and more benefits to more veterans. As the son of a Korean War veteran and as a veteran and National Guard officer who has been wearing the uniform for over 36 years, I view my role in the VA as a sacred duty. My philosophy at the board is to be veteran-centric in everything we do, whether our work, improvements, or new initiatives. It is an honor to work with so many dedicated veteran law judges, decision-writing attorneys, and administrative professionals who all share the same objective: to swiftly and fully resolve appeals for veterans and their families to the fullest extent of the law with fair and final decisions by a judge. I want to thank the committee and Congress for adopting the Appeals Modernization Act and providing subsequent budget support. It has enabled us at the board to build capacity during the past 2 years and through this year. It is paying huge dividends for veterans. Last year was the first time in 5 years since AMA implementation that the board's pending caseload dropped. With Congress's support, we plus up our judges' corps by over 30% and are on pace to do the same with our attorneys. A year ago, the board's pending workload was almost 216,000 appeals. Today, it is under 206,000 appeals. A year ago, we were averaging 1,900 cases per week. During the past few months, we have averaged over 2,300 decisions per week, and that will continue to grow over the next year as we reach full capacity. It takes time to hire right and train right to ensure high quality, and we're doing it. Quality assurance rates have never been higher, consistently around 95% each month. That is veteran-centric. AMA adjudication is also growing exponentially. Last year, at this time, only a little over 25% of the board's output was AMA adjudications. Today, it is consistently over 60% each week and growing. This is significant because AMA cases have 20% lower remand rates and 10% higher grant rates compared to legacy cases. In short, we're able to fully resolve AMA cases 3 to 4 years faster than legacy cases, and that gap is growing. We set a record last year with 103,245 decisions, and we will set another record this year with at least 111,000 decisions. That is veteran-centric. The board is concerned with any legislation that stifles this veteran-centric progress. Some of these proposals return to legacy-type rules, while others add unnecessary administrative burdens that will only make us go slower with no discernible benefits for veterans. I am concerned that some of today's witnesses appear to support recreating legacy-type rules in the AMA. This will have a dramatic and adverse impact on wait times for veterans with pending appeals. Incentives matter, and slowing down the line does not help veterans. VA supports HR 3651, the Love Lives Lives On Act, if amended. VA also supports the removal of remarriage restriction requirements for surviving spouses. VA also supports HR 1083, the Caring for Survivors Act, if amended. VA has provided suggested edits for clarity in our testimony. This concludes my testimony. My colleagues and I stand ready to respond to any questions you may have.
Thank you, Mr. Chairman. Colonel Wagner, you're now recognized for 5 minutes.
Good afternoon, Chairman Luttrell, Ranking Member Pappas, members of the committee. The court limits its testimony to 2 of the bills under consideration, specifically 3 sections within those bills that directly impact the court. Respectfully, the court does not support passage of these provisions for the following reasons. First, proposed Section 5D2 of the Medical Disability Examination Improvement Act of 2024 would add an additional element to the court's annual workload report, directing the court to summarize recurring issues it believes could be resolved by better VA training or by increased oversight or clarification from the Department or Congress. Respectfully, such an executive function rests with the Secretary. As a judicial body with exclusive jurisdiction to review individual board decisions, the court is not in a position to opine generally on internal VA processes or suggest how the agency could or should better manage resources or train personnel. Like all courts, the Veterans Courts must speak through its individual judicial decisions and does not issue advisory opinions. Respectfully, as a recipient of every decision that is reversed or remanded by the court, the board is responsible for and is in the best position to evaluate error trends in its decisions, allocate resources, and develop corrective strategies and training. The second bill I'll address is the Veterans Appeals Efficiency Act of 2024 and two specific provisions within it. The first would give the court supplemental jurisdiction to review eligible claims that are pending a final agency decision. The court is concerned that, as written, the proposed statutory language lacks clarity and could result in unintended broad construction that could significantly grow the court's caseload and, in turn, require reevaluation of the court processes and resource needs. Finally, the second provision of the Veterans Appeals Efficiency Act would statutorily authorize the court to order a limited remand to the board while retaining jurisdiction over the remanded matter. Respectfully, the court already has the authority to take the actions contemplated in this proposal, and indeed, the proposal may inadvertently limit the court's current authority. In conclusion, the court takes seriously its mission to afford veterans and their families and survivors full, fair, and prompt judicial review of final board decisions. We are open to ways to improve the court's functioning and sincerely appreciate the subcommittee's continued interest and effort in this shared goal. I'm happy to answer any questions.
Thank you, Colonel. Mr. Shedd, you're recognized for 5 minutes, sir.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. My name is Daniel Shedd, and I am a legislative attorney in the American Law Division with the Congressional Research Service. Thank you for the opportunity to testify on the proposed legislation entitled the Veterans Appeals Efficiency Act of 2024. My oral testimony will focus on the proposal to authorize the Chairman of the Board of Veterans Appeals, or BVA, to aggregate appeals pending before the board. Aggregation involves grouping together claims or appeals that have similar questions of law or fact for collective resolution or processing. Aggregation can take different forms. One of the most well-known devices for aggregation is the class action lawsuit. It provides a good example of what claim aggregation seeks to achieve. A class action allows a large group of similarly situated claimants, known as a class, to challenge a defendant's unlawful conduct in a single lawsuit rather than through numerous suits initiated by individual plaintiffs. A single plaintiff can file a claim not only for himself, but on behalf of the class as a whole. And the outcome of the case binds the defendant and the entire class, even if the other class members do not participate in the proceeding. The Supreme Court has explained that one of the principal purposes for allowing class actions is to promote judicial efficiency. For example, if you have 1,000 people that have been wronged in essentially the same way, the thinking is that it is more efficient use of adjudicatory resources for one judge to determine the answer once for all 1,000 people instead of multiple judges hearing the same factual and legal arguments 1,000 times over. Achieving this adjudicatory efficiency is one of the purported goals of all forms of aggregate procedures. They also provide for consistent outcomes for similarly situated parties because all parties are bound by the same decision. On the other hand, aggregate procedures may also have potential drawbacks. Although aggregation may provide for some judicial efficiencies from a big picture perspective, some commentators suggest that aggregation also adds increased complexity to individual cases subject to those proceedings. Courts and agencies that have used class action proceedings note that these aggregate adjudications can occupy significant adjudicatory resources and time. As a consequence, Individuals involved in a class action may be delayed in obtaining justice. Further, legal commentators note that there may be fairness concerns with regard to aggregate procedures. From the perspective of a person that can be bound by a judicial proceeding that they never took part in, it might seem antithetical to one of the quintessential American understandings of justice. That is, everyone gets their day in court. Currently, the BVA has no procedures in statute, regulation, or practice that provide for the aggregation of appeals. The Veterans Appeals Efficiency Act of 2024 would permit, but not require, the chairman of the board to aggregate similar claims. This broad permissive authority in the bill appears to comport with congressional delegation of broad powers to agencies in order to allow them to develop policies and practices that best fit their adjudicatory model. I thank you for the opportunity to testify today, and I look forward to your questions.
Thank you, Mr. Shedd. We'll move to questioning. Colonel Wagner, in your opening statement, you said that some of the legislation, you disagree with some of the legislation that this body's put forward, and that the court itself has the ability to act on the issues without this legislation being pushed forward. Yes?
That is correct. For limited remands, the court already has the authority to take limited remands.
So my issue is, this legislation was created for the court's inability to act on those issues. So we've presented this to you. So with you all saying that you have the ability to do so, but our constituents are the ones saying that this is an issue, now we're in conflict. So I'm going to need you to explain to me why that's, because if the court itself could acted on this without it being raised up to the congressional level here at this committee today, we wouldn't be having this conversation, but here we are. So I can't really sit here and say I agree with what you're saying because it's not holding water.
Understood, Chairman Luttrell. The court does currently have the authority to issue limited remands. However, it has not been used, it has been used sparingly by the court.
Why?
That is an issue of judicial discretion. Each judge may look at an issue as the cases, as they come up on an individual basis, looking at the veteran's claims, and they make the decision whether or not to do a limited remand. One of the reasons that judges may choose not to order a limited remand is a concern that it's going to disrupt the claims that are in queue at the board. When a court issues a limited remand, they send it back for re-adjudication. If it's limited, they're going to retain the jurisdiction. If they send it back, the veterans are on claim at the queue. That will be disrupted because there are parameters put on that limited remand, time constraints that they would take priority over the other traditional remands. And that may just be one of the reasons. I cannot talk for all of the judges. I am just giving an example of what may be a thought process that the judges have on that. It is really comes down to judicial discretion and the tools that they use in the toolbox.
Imagine us having to explain that to our base. Okay? Mr. Chairman, do you believe that the board's quality rates should reflect all error data coming from the veterans' courts, including data on joint motions for remand? Yes.
So let me go ahead and, we take quality very serious, Mr. Chairman, and the data that is done now, it's basically we do a sample of cases before we even assign them. We say we're going to take all these cases and follow them and review them when they come out. So that is the pool that we review. It's been done generally. So remember, we've been doing more legacy cases than AMA cases. We're now focusing on AMA cases. So going forward, we are reviewing more AMA cases, not only because it's a majority of the cases we're doing now, but also because we want to ensure the AMA quality. So that's how the quality process works now, Mr. Chairman.
In your opening statement, you said there's going to be folks in the crowd that are going to try to defend the legacy process. Is that how you put it?
So what I said is a number of the provisions in the options Act, in that bill, open and bring back in a number of concepts that were existing under legacy. But all the stakeholders got together, Mr. Chairman, and came with what we believe is a much better process, which is AMA. For example, one concept is following that the judge that does the hearing is the judge that gives you the decision.
Yes.
As you know, I've been in this position for 2 years. I came in, and that sounded very reasonable to me. So I've instructed for that to be done whenever possible. But to make it a requirement, like it was under legacy, could have very negative effects. You have a judge that goes on extended leave. I'm going to have to hold that case because that judge was the one that did the hearing, and then the judge, we need to wait for that judge to do the decision. So that is the common sense changes and veteran-centric. It's all about the veteran experience. So I understand if we can match it, we will match it, Mr. Chairman. But we don't want to have it a requirement as in the case of legacy. A number of, to ensure the line moves, if you get a case and the case goes to the court and the case has to be remanded back, you get back in the line. Under legacy, you would keep your place in line. So that's what would generate a lot of churn. And remember, cases that come back from the court, the veteran doesn't necessarily get a change in benefits, but many of those JMRs they just go back in the system without a decision by the court.
Okay, thank you, sir. Ranking Member, you recognize, sir.
Thank you, Mr. Chairman. I do think there's consensus among members and stakeholders as well that the full benefits of the Appeals Modernization Act haven't yet been realized. And I think one of the reasons is these legacy appeals, which the board hasn't cleared out as quickly as you'd initially projected you would. I think there's also this feedback loop between VBA and BVA regarding quality that's not working as well as it could, and I think that has slowed things down as well. Claims have gotten stuck in a feedback loop with multiple remands. So, Mr. Chairman, you were talking about the success story here over the last few years. You talked about building capacity, pending case loads dropping, QA rates improving, but I'm really concerned about the challenges, the areas that aren't going well. We're not just on this glide path that's going to continue. Where do you see the challenges ahead? And very importantly, what kind of feedback are you getting from attorneys, from VSOs, from stakeholders about challenges and progress and where things need to go for as we look out into the future?
Thank you for your question, Ranking Member Pappas. It's definitely a half-full glass story, and I'm an optimist, so I recognize that. I do think that the AMA, it's now finally coming into full implementation because, as you know, over this 5 years, we've had to operate under two systems. We had a majority inventory of legacy cases that continue to operate under the legacy rules, and then we had a new AMA, so we've been managing those two. Fortunately, we are at the end of legacy, and for the first time, we are in a majority AMA world, and that is showing the benefits of AMA. Challenges. Well, one of the challenges has been raised by the committee, and we take it very serious, is to ensure training. So one of the questions that has been raised by the committee is what we're doing on the training side. And I can tell you that we are head on with training. Just last week, we had all the judges for a week of training here together for only the second time in the history of the board. The reality is that we are scheduling and hosting over 300 trainings per year for our team members, whether judges or attorneys. So that's one challenge. The other challenge, Mr. Ranking Member, has been the remands. I recognize that the remands are a challenge because you get in line, you get for a decision, and you don't get a decision in a high number of cases. So we've been laser focused in identifying why are we having remands. I've been telling the judges, I cannot force you to make a decision, military, undue command influence, but I can tell them, hey, you're not doing any good for a veteran. Veterans want finality. So we are doing training, and we're doing a whole system to ensure that we reduce remands. Just last week, out of those 24 hours of training we gave the judges, 8 hours were dedicated to implement the GAO recommendations We've already implemented the first two. That's recommendation number 3, to ensure consistency and a reduction of remands, and that's what we're doing, Ranking Member Pappas, to deal with that challenge.
Thanks for those comments. I want to move on to a different issue, and Ms. Pierce, maybe I can direct this to you. We're considering a couple of bills to address issues communicated to us directly from VA's frontline employees regarding overutilization of toxic exposure risk activity exams, specifically for claims that are seemingly unrelated to toxic exposure. The exams and subsequent memos VSRs must create as a result of them have the effect of slowing down the processing of a claim. And according to your testimony, VA is largely rejecting both of those proposals. So in your opinion, Ms. Pierce, what can Congress do to alleviate the increased workload extraneous toxic exposure exams have imposed on employees? And is it possible to preserve VA's duty to assist while also narrowing the scope of terror exams?
Thank you for the question. There are a large variety of different things that could be done to impact the mandatory requirements for the terror exams. Both of these bills take different approaches to doing so. We have identified some operational challenges ourselves with claims related to terror taking approximately 33 days longer than other types of claims, and the large volume of terror exams that are being requested, resulting in a relatively low grant rate related to all other claims. But we have identified that there are some limitations in our data, how we're collecting data on terror, and we've heard perspectives from our employees, from VSOs and other stakeholders. And so we've set up a terror data work group to analyze the data, look at potential policy, procedural changes, or system updates that could enhance how we're providing benefits to this population. We want to make sure we're taking a deliberate approach. So I don't have any concrete recommendations on what could be specifically done, but I would draw attention to the provision in the Toxic Exposure Examination Improvement Act that would amend the definition of TERA in 38 U.S.C. 1710, specifically adding a qualifier that a TERA would be established for an entry in an exposure record tracking system that specifically indicates a veteran was subject to toxic exposure. We don't support that because it limits both health care and eligibility for examinations, because that's a health care statute. Amendments to potentially make changes to the mandatory requirements for TERA exams should consider any unintended consequence on also limiting health care eligibility.
Thanks for those comments. I'm way over my time, but I hope we can continue talking about this. I yield back.
Thanks, sir. Mr. Self, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, before I get to my questions, how many legacy cases are remaining?
Sir, some of the inventory is at BBA, and some of it is at the court. At the board, we have 12,000, sir.
12,000, okay, thank you. So, Mr. Chairman, accountability is often an issue in our hearings with VA in every area. If I understood your testimony correctly, for decades, the board has held the VBA accountable for failing to comply with the board's orders. Did I understand your testimony correct that the board should stop doing that?
Thank you for your question, Congressman Self. The board doesn't hold accountable. What the board does, it reviews. So under the AMA, between legacy and AMA, in legacy, the veteran only had one option if they did not accept the decision of BBA, and it was to appeal to the board. Under AMA, as it is veteran-centric and it looks for veteran choices, the veteran has an option to do a higher level review appeal at BBA. That is working very well. Many veterans are taking that choice. BBA has grown exponentially their number of decisions, up to 2.4 million a year. We are still seeing the same number of appeals, Mr. Congressman. So when it comes to us, the judge reviews it, it can grant it, it can deny it, or it can say the information is not enough, or there's another issue that needs to be reviewed, and it remands it back to BBA, sir.
Okay, that's the process, but I'm talking about accountability. Who's holding VBA accountable for board orders, is the bottom line.
Sir, that is the system. That is the system because by going back, it goes back to their inventory and they act upon it. And we would expect that, in the second time.
So it is a self-policing process.
It is, but let me go ahead and turn it over to Ms. Ogilvy because we've created a Tiger team to coordinate issues and work through interfacing.
Okay? Ms. Ogilvy?
Yes.
You've been very patient.
As to remand and VBA's adherence to the remand instructions that are sent from the board, that is overseen by VBA. Yes, it is self-policing, but it is through our quality system. So we have in-progress reviews, and we have reviews that happen after the fact, quality reviews. We also, as the chairman mentioned, we have a Tiger team within VBA and at the board that looks at the instructions themselves as well as the adherence to those instructions. And we have a feedback between BVA and VBA to discuss any problematic instructions that may cause concerns or if the VBA is not adhering to those instructions.
So who ultimately holds the authority to hold VBA accountable? Is it within VBA?
Yes, it is within VBA.
I thought that might be the answer. Okay. Ms. Ogilvy, for you again, does DOD consistently classify entries in EILR as toxic, even though they may or may not be toxic?
I'm going to actually defer that to Ms. Pierce.
Okay?
Thank you. So the EILR system collects a lot of different information. There's a lot of surveillance of exposure events that takes place. So typically...
Okay, my question is very narrow. Okay. Let's narrow to the question. Do you overclassify? My question is, do you overclassify toxic versus non-toxic? Because I'm trying to get to the number of TARA exams that we have.
Yes, there are definitely entries in EILR that are not related to toxic exposures, related to just routine monitoring of substances at locations, as well as just health assessments that are totally unrelated.
So the PACT Act requires a TARA exam if they see an entry that is toxic. Is that correct?
As we have interpreted, essentially any entry in EILR would trigger both eligibility to health care and an exam under Section 1168 based on TARA.
Any entry. Is that what you said?
Yes.
I think we've identified the problem. Mr. Chairman, I yield back.
Thank you, myself. Mr. Duarte, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. It's great to be here with the committee today. Appreciate your time. Appreciate the panel. So Colonel Wagner described the veterans courts and remands, and some judges do it some way and some judges don't do it as much, and it seems like, is that based in a vagary of the law itself or a vagary of the understanding of the law or judge's preference?
Congressman Duarte, I believe it's really a judicial discretion issue. When a case becomes in front of the judge has a decision, when they review the decision of the board, the final decision of the board, whether or not they're going to affirm, reverse, or remand. And one of the reasons there is a high remand case is that there are two ways that board decisions are remanded back to the board. One is by judges remanding it back where they find an error, where they find that the board is not clearly laying out the facts or developing the facts. The court does not have the authority to fact find in the first instance. So if there is a fact that needs to be resolved, it must be sent back. There is no other alternative but to send it back for re-adjudication to develop those facts.
Sure.
And then also, when a case comes to the court on appeal, the first process is that the Veterans Council, as well as the Secretary's Council, attend a conference where they are mediated by a court's staff, and they discuss the summary of the issues before the court, and the parties agree that there are errors in the board's decisions. And in 76% of the cases that are conferenced are remanded back, where the attorneys agree that there is an error by the board. And that is a big chunk.
Okay, thank you. That's, Mr. Shedd, you've done a lot of research on this type of stuff. I've seen a couple of your documents. Is the case, in your opinion, Is the case law crystal clear as to whether Veterans Court can issue limited remands?
Thank you for the question. Most recently, the court in Score versus Wilkie issued a limited remand where it sent the case back to the BBA with instructions to hear additional evidence with a strict timeline, as this bill would clarify that it can do. The dissenting and concurring opinions made it difficult to determine whether or not when limited remands should be used. And the majority opinion did not, although it indicated that it is appropriate in certain circumstances, did not indicate when those circumstances, or what those circumstances.
Okay, well, thank you. That's an offensive. Ms. Pierce, so I've got the Clear Communication for Veterans Claims Act, and I understand the Veterans Administration has some concerns about the bill. If Congress compelled a third party to collaborate with the VA, would that alleviate the VA's concern that the entity's recommendations for improving notice letters might be non-compliant with the law? And is the law clear enough to where even the VA itself can give clear direction as to what is certain in terms of clarity and consistency with the law?
I'll divert that question to Ms. Ogilvy.
Thank you for the question. So yes, so VA believes that legislative action here is not required for a comprehensive letter review. VBA's business line already engage in continuous improvement of notification letters, and there's an existing governance process in place. But there is, the concerns that we have with this bill specifically are about the legal issues that you mentioned.
Well, I think that's the essence of our problem with not having the bill, with not having a reformed Clear Communications for Veterans Act, is these letters are so full of legal concerns and self-protections of the agency that they can get up to 20 pages long. And I mean, I, as a layman, not familiar with Veterans Affairs, I'm lost in your jargon and lingo to some degree today, but that's my problem. I jumped in on the committee. But these veterans have serious life issues hanging on there, and I don't think they need more legalese. I think these veterans need clear communications that is focused around themselves, their cases, their needs, and the resources available from the Veterans Administration to get it to them. And I have a feeling if I left every legal issue to be clarified by the VA itself, these letters would go from 20 to 30 pages, not from 20 to 2 pages.
So our concern with the bill is that it leaves no room for VA to clarify or refine some of the language that the FFRDC would recommend. So we have no issue with an FFRDC looking at letters and suggesting improvements. The language as written makes it mandatory for VA to accept that language, and there are legal issues that the law does lay out things that we must tell the veteran in every letter, especially notice letters, and we don't want that to be something that will be a risk for veterans as well, because they do need to be aware of their rights.
And do these letters have an executive summary at the front that tells them what their issue is and what they can do? And then all the boilerplate and legal mumbo jumbo, as we generally call it, when we're buying a car or a house, an insurance policy or whatever, can be at the back? My understanding is these letters are coming to the veteran where this stuff is more front and center and commingled with the useful information than it is put as a disclosure, as is the case in most transactions.
Yes, in some letters, like notification letters, there is kind of a bottom line up front about whether there's been a grant or denial of the claim and what kind of payment that the veteran can expect. And the appellate rights and other rights are at the back.
That's in some letters.
In some letters, yes.
But we're not confident that that's consistent, that every veteran is going to have that luxury of having a clear set of information up front versus commingling it and hiding it to some perspectives within the body of a long legalese and confusing letter.
Yes, that's correct, sir.
And so if you have involvement to make sure all of your legal disclaimers are there somewhere, I think a company that has skills in bureaucratic engineering and informing for customer satisfaction, because that's ultimately what we're trying to do, is going to know what to put up front and what to put in back. I don't think they'll limit your legalese. I think they'll just get it out of the way and kind of where everybody else puts it. Thank you, Chairman. I yield back.
Thank you, Mr. Duarte. Mr. Duarte, do you have another question, sir, for a second round?
Not for this panel, no. Thank you, sir.
Okay. Ms. Ogilvie, just to piggyback off what Mr. Duarte was saying, is there a specific regulation or reason why every member doesn't receive, as you said, the bottom line up front on the front page of every letter that's sent to them? That just seems like that would work so much better than the letters that don't have that. So is there something in place that's preventing that from happening?
No, there's not. And
Outstanding.
I would just note that also, after the recent hearing on letters, we've also been working very closely with VSOs and other attorney representatives to get their feedback about letters that are specifically
Great. I'm pretty sure I asked you guys to do that. So
Yes, and
outstanding.
we're looking forward to the May roundtable to discuss this further.
Okay, perfect. All right. On behalf of the subcommittee, I thank you for your testimony and joining us for today. You're now excused. Third panel, you may approach. Good afternoon. I'm assuming Ms. Pierce is not joining us with this panel. Is that correct? Just so I don't mess that. Okay. Our third panel includes Ms. Candace Wheeler, Director of Government and Legislative Affairs for the Tragedy Assistance Program for Survivors, Christopher Wasinkovich, Deputy Director for the National Veterans Service at Veterans of Foreign Wars of the United States, and Mr. Andrew Tajan, First Vice President of the National Associations of County Veteran Service Officers, and Ms. Renee Burbank, Director of Litigation of the National Veterans Legal Service Programs. Would the witnesses please stand and raise your right hand? Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Thank you, and let the record reflect that all witnesses answered in the affirmative. Ms. Wheeler, you're now recognized for 5 minutes to present the testimony of the Tragedy Assistance Program for Survivors.
Chairman Luttrell and Ranking Member Pappas, and distinguished committee members, the Tragedy Assistance Program for Survivors is grateful for the opportunity to testify today on behalf of over 120,000 surviving families TAPS is honored to serve. A top legislative priority for TAPS is ensuring surviving spouses are allowed to remarry at any age and retain their benefits. Current law penalizes them if they remarry before age 55. Given that many post-9/11 surviving spouses are widowed in their 20s or 30s, we are asking them to wait 20-plus years to remarry and retain benefits. Surviving spouses should not have to choose between remarrying and financial security, regardless of their marital status. They will always be the widow or widower of someone who served and sacrificed for our country. TAPS is proud to work with Representatives Phillips and Hudson on the Love Lives On Act to address this important issue, and we urge its swift passage. We also request that CBO reconsider its scoring of this bill based on VA's much lower cost projection and the fact that surviving spouses who remarry do not retain their TRICARE or CHAMP VA insurance, which is a major cost savings to the government. Another priority for TAPS in the survivor community is strengthening dependency and indemnity compensation. Stringent limitations on DIC payments to surviving families have financial and widespread impacts. As surviving spouse Katie Hubbard states, increasing DIC would allow me to be able to afford groceries and childcare, medical expenses, and home and car maintenance while just trying to survive. We strongly support the Caring for Survivors Act and thank Representative Hayes and Fitzpatrick for reintroducing this important bill. Raising DIC from 43 to 55% of the compensation rate paid to a 100% disabled veteran will provide parity with other federal survivor programs. In addition, we thank Chairman Luttrell and Ranking Member Pappas for introducing the Veterans Compensation and Cost of Living Adjustment Act, which will help increase DIC. TAPS appreciates Congressman Subcommittee and Chairman Bost for introducing the Prioritizing Veterans Survivors Act, which would return the Office of Survivor Assistance to its previous location within the Office of the VA Secretary. OSA was established by law in 2008 to serve as a principal advisor to the Secretary and as a resource for surviving families regarding benefits, care, and memorial services. In its current placement within pension and fiduciary services, survivors lack daily representation before the Secretary, depriving critical insights and perspectives. With more than 505,000 survivors eligible for DIC, OSA staffing should be significantly increased to better serve surviving families. OSA should be the official entry point into VA for survivors, with the authority, bandwidth, expertise, and access needed to address any challenges that survivors face regarding all VA benefits and services. TAPS also recommends creating a dedicated survivor helpline within the Veterans Call Center to provide access to trained agents with the cultural competency and compassion to address survivor issues enterprise-wide. We appreciate VA recently holding a survivor summit to gain valuable insight and input from survivors and key stakeholder organizations to ensure survivors receive the highest quality of services and support they deserve. TAPS thanks Ranking Member Takano for introducing the Survivor Benefits Delivery Improvement Act to improve access to VA survivor benefits through the collection of demographic data and to ensure necessary resources for survivors. TAPS recommends adding cause of death as a track demographic. This data would be incredibly important to understand the different types of losses survivors face, as well as creating programming and resources that are relevant for all survivors. In closing, TAPS thanks Congresswoman Strickland for introducing the Fairness for Service Members and Their Families Act. We appreciate the importance of reviewing the automatic maximum coverage of the service members and veterans group life insurance programs, and would ideally like to see both the SGLI and VGLI fully tied to cost of living adjustments and inflation to ensure it maintains the intended rate long-term. On behalf of our nation's surviving families, we thank this committee, and I look forward to your questions. Thank you.
Thank you, Ms. Wheeler. Mr. Misinkiewicz, you're now recognized for 5 minutes to present the testimony of the Veterans of Foreign Wars in the United States.
Thank you. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States and its auxiliary, thank you for the opportunity to provide testimony with regard to this pending legislation. As the former VFW Training and Quality Assurance Director, I am keenly aware of how quickly and often VA regulations change, as well as the need to ensure that updated regulations are understood by those who use them. Recently, I was representing a veteran from Maryland who had a claim for a mental health condition denied by VA. The veteran had claimed PTSD on the initial application for benefits. However, during the C&P examination, the examiner diagnosed a different mental health condition and provided a medical opinion linking the condition to active military service. Though there is a 2009 Court of Appeals case that directly references this type of situation, and VA's own regulation states that raters are required to consider all the mental diagnoses in the record, a VA rating officer denied the claim because the veteran did not have PTSD. Though the referenced court case and the regulation both state that the rater was supposed to consider all mental health diagnoses of record, without proper training in plain language, this regulation is often confused, thus causing an unnecessary appeal. The VFW supports the Veterans Claims Quality Improvement Act of 2024, which would provide much-needed training and oversight for those deciding VA claims. However, addition of more oversight often comes with delays in timeliness if the program is not properly funded. This bill instructs the General Counsel to review each updated VA regulation and develop a training program to ensure that those writing the regulations are properly trained. It also instructs the Board of Veterans' Appeals to create a training and quality assurance program. While training and oversight is essential, without proper funding for these programs, the development and execution could be severely impacted, thus limiting the effectiveness of these programs. Since the creation of the VA National Work Queue in 2016, VFW accredited representatives have seen numerous instances of claims and appeals that have been sent to the National Work Queue where they sit unassigned and unworked by VA staff. In a recent VA meeting, VSOs were briefed that once a claim is in the National Work Queue, it is not uncommon to be untouched still at the 6-month mark. The VFW can definitely corroborate this. In fact, one of our own service officers submitted a claim for an increased rating more than 10 months ago, but it's still sitting in the National Work Queue untouched. This is one of many examples of claims and remanded appeals that are waiting in this queue. The Veterans Appeals Efficiency Act of 2024 would require the Secretary to track claims in the National Work Queue, submit an annual report, and provide notice to veterans of the reasons why their claim is still waiting in the National Work Queue. The VFW supports this intent, but feels that there needs to be more guidance regarding the delivery and language of the notifications to veterans. During the claims process, veterans are often inundated with different notifications from VA, which can be confusing, overwhelming, and repetitive. Simply sending another notification to the veteran that their claim is pending in the National Work Queue will not answer the question as to why their claim is waiting in the National Work Queue. Therefore, we recommend that accredited VSOs be included in the development process to ensure that the messaging and notifications is clear and effective. The VFW also supports H.R. 7816, the Clear Communication for Veterans Claims Act. One of the primary challenges veterans encounter when reviewing their disability notification letters is the intricate language and terminology used. Far too often, accredited representatives spend a great deal of time explaining letters that make sense to the trained eye, but not to anyone else. The VA disability system involves a multitude of regulations, policies, and procedures. Unfortunately, these guidelines can be subject to interpretation, resulting in inconsistencies in notification letters and frustration on part of the veteran. Understanding the full spectrum of benefits associated with a disability rating is another hurdle for veterans. Most notification letters include information on additional benefits, but veterans may struggle to connect these pieces of information to effectively assess the services to which they are entitled. This lack of clarity can impede veterans' ability to make informed decisions about their health care and overall well-being. The VFW supports effective notification and believes that veterans should not be penalized for not understanding the complex laws of the VA process. Chairman Luttrell, Ranking Member Pappas, this concludes our testimony, and I am happy to answer any questions that you may have.
Thank you, Ms. Sinkwich. Mr. Tangen, you're recognized for 5 minutes, sir, to present the testimony of the National Associations of County Veterans Service Officers.
Thank you. Chairman Luttrell, Ranking Member Pappas, and distinguished members of the subcommittee, the National Association of County Veterans Service Officers would like to thank you for the opportunity to submit our views on pending legislation impacting the Department of Veterans Affairs before the subcommittee. My name is Andrew Tangen, and as the first Vice President of NACVSO, I am honored to speak to you before you today. Due to the highly complex and technical nature of these pending bills, I would like to focus my oral testimony on the importance of Congress's continued efforts to improve the appeals process for veterans and survivors, specifically surrounding the Board of Veterans' Appeals. Many times, veterans and survivors are trapped in a cycle of repeated denials for benefits owed to them. It starts with a decision at the VA regional office, is sent for review by the board, then returned to the regional office for a denial. It is appealed and then reviewed again by the board, and then sent back to the regional office for another denial. Then another appeal, another denial, another appeal, and denial, becoming an endless loop that can take years to complete. I could spend days describing individual cases where we as GVSOs have seen this exact scenario play out, but in the interest of time, I will speak only on one of the most egregious cases I have personally witnessed. My office represented the widow spouse of a Vietnam-era veteran through multiple appeals and re-adjudications of a veteran who died of MRSA without ever being diagnosed with it. The veteran was experiencing left side weakness and loss of balance, so he went to his primary care physician in November of 2007. A CT scan found an abnormal finding, so he was admitted to Edward Hines VA Medical Center for a brain biopsy, chemotherapy, and radiation to reduce the size of a tumor he had and needed surgery on. However, this veteran was found unresponsive 1 month later. He looked incredibly sick and was running a high-grade fever. The veteran also immediately began to lose the ability to speak and could not open his eyes and passed away a week later. The widow began attempting to uncover what happened to her husband and reached out for help from former Congressman and Senator Mark Kirk. Congressman Kirk sent 2 requests for lab results to the VAMC regarding the veteran's death. The results showed the veteran had been diagnosed with MRSA, but that was never recorded in his medical records at Hines VAMC. Following the diagnosis, the Hines employees gave the widow a pamphlet explaining the contamination procedures the widow needed to know because the veteran had tested positive for MRSA. Unfortunately, the veteran was already dead. You'd think that would be enough, but it isn't. The spouse was denied benefits twice under a 1151 claim based on VA negligence. Upon appeal, the widow and her daughter testified about the lack of care provided to the veteran to such an extent that the daughter specifically testified that she had to wear a gown and protective equipment when she went to see the veteran 2 days before he passed, and that her father's tongue and mouth were blackened like a hot dog that had been left far too long on a grill. The board still denied the case, stating it remained an unestablished fact that the medical evidence existed that the VA hospitalization, medical, or surgical treatment resulted in the veteran's death. My office stepped in to represent the widow in 2020 at the Court of Appeals for Veterans Claims, where we pointed out medical treatment was not provided correctly. We also retained an internist with 40 years of medical experience and 35 years of medical malpractice expertise who determined VA providers negligently treated this veteran's MRSA infection. The case once again went to the board, was remanded to the regional office for a new forensic examination, where the testimony of our expert witness was completely ignored and the claim denied again. We again appealed the case, correctly pointing out the failure to consider our expert witness 5 more times. On the 6th remand, the VA finally ordered an examination, this time by a high-level VA provider who immediately determined the VA failed to treat the veteran's MRSA infection, failed to follow VA procedures, as well as failed to follow guidelines from the Infectious Disease Society of America and the American Thoracic Society. It took 15 years, 15 long, unnecessary years of constant back and forth between the regional office and the board before the widow was finally awarded benefits for the death of her husband. Unfortunately, this is not an uncommon occurrence. This happens repeatedly and consistently, whether in the appeals or the legacy appeals of the Appeals Modernization Act. Ultimately, it should never take 15 years for a widow to receive benefits she rightly deserves. Chairman, ranking member, and members of the subcommittee, on behalf of NACVSO, thank you for the opportunity to submit our views on some of these bills pending before being considered today, and we look forward to working with you on the legislation and would be happy to take any questions for the record.
Thank you, sir. Ms. Burbank, you're now recognized for 5 minutes to present the testimony of the National Veterans Legal Services Program.
Good afternoon. Thank you, Chairman Luttrell, Ranking Member Pappas, and the esteemed members of the Disability Assistance and Memorial Affairs Subcommittee. On behalf of the National Veterans Legal Services Program, thank you for the opportunity to testify before you today on ways to improve the claims adjudication and particularly the appeals process at the Department of Veterans Affairs and the Court of Appeals for Veterans Claims. NVLSP is a nonprofit veteran services organization founded in 1981, and we're dedicated to ensuring that our nation's 18 million veterans and their families receive the benefits that they need and deserve for disabilities resulting from their military service to our country. For the sake of time, I'd like to focus, though, on just a couple of issues, and particularly the Veterans Appeals Efficiency Act of 2024 and the provisions relating to the Court of Appeals for Veterans Claims. This is not a one piece of legislation, is not going to fix everything about the delays, the inefficiency, the inconsistency of decisions. But these tweaks will make a difference, and NVLSP supports taking a multifaceted approach as reflected in the legislation you're considering today. The Veterans Appeals Efficiency Act will provide to the CAVC several tools for its toolbox that will make sure that the Veterans Court
has the same kind of authorities as other federal courts do when they review other federal agencies' actions. The Veterans Court should not be hampered in its ability to act efficiently and craft effective and timely relief for veterans. In particular, NVLSP strongly supports codifying the court's authority to issue limited remands to the board. Basically, this means that the court can, when it thinks it's appropriate, send a case back to the board to answer a narrow question that the court needs answered before making its decision. Limited remands can help reduce the churn that occurs when a case goes back to the board, and then back to the RO, and then back to the board, and then back to the court. Instead, with a limited remand, the court can get the board to act narrowly and quickly. And then the case comes right back to the court to resolve the case, hopefully for the last time. Other courts routinely do this when they're reviewing agency actions. They don't use it all the time, but where the court is particularly skeptical of the agency getting it right on remand or is concerned about undue delay, this is a useful tool to have. The Veterans Court should have, and we believe does have this authority, but it should be clear, and it should be clear that this is an appropriate tool for the court to use. NVLSP also supports the CAVC's ability to use its class action authority for aggregating claims in the way that other courts do. Right now, the CAVC's ability to use its class action authority is narrower than any other federal court's class action authority because of the way the Federal Circuit, the court that reviews CAVC decisions, recently interpreted the CAVC's limited jurisdiction to prevent considering common questions of law on claims that do not yet have final board decisions. Giving the CAVC the power to issue class action decisions that affect all veterans with the same issue is vital to make decisions fair, consistent, and improve efficiency by deciding a common legal issue for everyone at the same time. With that, I will restrain myself from talking about all of the other provisions, and therefore just thank you for your time, thank you for the opportunity to testify, and we welcome any questions.
Yes, ma'am. Keep going.
All right, I'll keep going. In particular, the discussion from the previous panel, there was a discussion about whether the Veterans Court has this limited remand authority. And the clerk of the Veterans Court stated in written testimony that this provision could inject uncertainty into the law and restrict the authority that they already have. With all due respect, NVLSP's position is that this bill will inject certainty. There is some lack of clarity between a couple of cases. Mr. Shedd discussed Cleary and
You can appreciate
Score.
the argument from the other side, I'm sure.
Excuse me?
You can appreciate the argument from the other side?
I think the key is that the provision as written does not require using limited remands in a way different from how the court already sees its authority. The problem is that several of the judges on the court have said explicitly in decisions, we aren't sure how this works with our other case law that says we don't have the ability to just keep jurisdiction on certain cases and send them back. So the ability to
They don't say that. From what I understand from the previous panel is that they have absolute understanding that that belongs to them.
they have not used that authority that they are now saying they have, right? And we agree that they have the authority. They don't use it very often. And
You can appreciate that I have to take what you were saying, what the previous panel said, because I'm looking at you as a subject matter expert and the previous panel, their subject matter expert, but I wasn't there. I didn't witness this. So now here we are once again in conflict. Is this a widespread, wide-casted net problem? Are these singularities that we're dealing with? Because the legislation that we're pushing across is exactly what you're saying is why we're doing it.
Right, so for example, there are two cases, and they're called Best and Mahl, M-A-H-L, and it's they're often referred to together, Best and Mahl. And so what happens with the Veterans Court now is that when there are, say, 5 issues that come in one case, and there's
one issue that should be remanded to the board. It's very clear that it should be remanded. There's some issue, maybe the board hasn't decided, hasn't explained its reasons for its decision. Under the case law that exists right now, that case has to go back. You take the low-hanging fruit, the court takes the low-hanging fruit and sends the whole case back. This would provide an opportunity and clarity that what the court could do instead is say, if there's just one issue that the board needs to just clean up part of its decision, it can come straight back to the court to decide an important issue, to decide an important legal question that otherwise may never come back to the court or may take years to come back to the court.
Mr. Tangent, you got anything for that?
So I would say, Chairman, I agree with NVLSP. We also agree with NVLSP on what they were saying as well. But I will also point out that there are many cases that come from the Court of Appeals to Veterans Claims back down to the board, that the board is not tracking the data on why they were sent back to them through remands, through joint motions for remand.
Like an individual or like the entire court itself?
So the board itself is not tracking what the reasons that their decisions were sent back through a joint motion for remand on those.
Okay, hang on for a second. I don't think anybody likes to beat up the VA more than I do. But I also can appreciate what they are and everything that they're trying to accomplish. And I do appreciate the struggles that you all are experiencing with the veterans that you're helping, right? I'm a veteran myself. I get it. But I'm not going to blame the entire board. I'm not going to, the court system. I won't do that. I find that really hard to believe, and I'm not getting on to you about this, but what I'm saying is I find it hard to believe that the entire court itself would not know that, or would not understand exactly what came back down to you all. That doesn't make any sense to me, how that would happen. You tell me it went up into the system, nobody took a look at it, and they sent it right back down to you, and you went up there and said, hey, what's the problem? You're like, we don't have any idea, we've never seen it?
No, Chairman, what I'm specifically referencing is that we had the AMA summit at the beginning of February, and this question was specifically asked to the board there. Out of the 9,000 joint motion for remands or returns from the court to the board, does the board track those reasons for remand from the court, and do they provide any training? And the board said no.
Okay, so it's just a documentation thing.
Correct.
Okay. Mr. Duarte, sir, you're recognized.
Thank you, Mr. Chairman. Thank you to the panel for being here today. Ms. Wheeler, thank you for being here. Can you elaborate on why TAP supports the Clear Communication for Veterans Act?
Yes, I'd be happy to. And first of all, thank you so much for introducing this piece of legislation. We have seen that survivors often struggle as well with clear communication. Oftentimes these letters, as we've all been discussing today, are down in the weeds and very hard for the layman to understand. And especially add a surviving spouse that is grieving on top of that. And trying to be able to understand what is being said to them, it would be very helpful to have it in very clear layman's terms up front, as we were all discussing earlier. What we also find with a whole letter type of back and forth between our survivors is that oftentimes it is asking them to prove that they have done something or to respond back. In the case of remarriage, a letter is sent to them that says, have you remarried? If they have not remarried, they're still supposed to send the letter back, which is wasting time for both the VA and the survivor. So we would like that communication not only to be clear, but also thoughtful in the sense of what you're asking. You may not need to have that reply. If they indeed need to respond back to the VA, then they can do so at that time. But that's one of the things that we hear repeatedly from survivors in terms of communication. But we also believe that for our veterans as well, making sure that it is in layman's terms upfront, understanding that the VA does need to put different types of legalese towards the back, but it would be very helpful.
Thank you very much for that answer. Ms. Burbank, do you think that the veterans would receive faster decisions if we authorize class actions at the VA Board of Veterans of Appeals?
I'm sorry, at the BVA or at the?
At the VA Board of Veterans Appeals. Do you think the class action lawsuit is going to help veterans access their outcomes and their benefits faster by allowing class action?
So class actions, as a rule, whether it's at courts or at a board, they are a tool of efficiency. They are designed to make claims go faster because you are dealing with issues once rather than dozens, hundreds, thousands of times. It relieves not just the one, it makes one case more complex, certainly, but it means that you're not having 100 cases, 1,000 cases.
But sure, the class actions, as we understand them in business, you've got a giant business that's going to be sued with a myriad of small claims from similar plaintiffs. You assume an adversarial position. You assume they need to unite through a big law firm who's going to take a very large percentage of the outcome of the award. In the case of veterans, where they have us here providing oversight, where they have veterans advocacy groups on the ground, do class actions make the same sense when the defendant oftentimes is the government represented by this committee and the Congress itself?
Sure, and class actions against the government in other circumstances also exist. And the whole idea is, yes, they are a tool that, again, not every case is one that is amenable to class actions, right? Sure. You have to have a common question of law and fact that's going to make it faster and more efficient to deal with all at once rather than every single time.
Great. And Mr. Tangen, I'll take your comments on either the Communication for Veterans Claims Act. Do you see these letters as frequently, and are they more obstructive than they have to be to the veterans getting access to their benefits without services from someone like yourself?
So I'll give a real quick story to answer your question. So my office represented a Vietnam veteran diagnosed with Parkinson's. He was an elected official in our county. He wanted to give up because of the amount of paperwork that he got from the VA, and came into my office with a box of paperwork and said, I don't want to do this anymore, keep reading this stuff. And I looked at him and I said, stop reading the letters, that's why you have me.
So it was virtually impossible for him to get his services and benefits that he deserved without an attorney as yourself.
That's correct.
And does that need to be that way?
I don't think so, no.
And it hasn't corrected itself as of yet through the Veterans Administration directly?
That's correct.
And you've given them some input over the years?
That's correct, Congressman.
I assume veteran groups have given them some input over the years, and it hasn't been fixed yet?
That's correct.
Thank you. Appreciate it. Yield back, Mr. Chairman.
Thank you, sir. Ms. Wheeler, I have a follow-on question for you about the spouses and the letters that they receive asking if they've been remarried, because current law states that if you're remarried before 55, you lose your benefits. By law, until this current legislation that we're trying to push through, if that's enacted and passed. Now, the VA, sitting in his room with us, their job is to reach out to those spouses and ask those questions. And I get it. Every time I get a letter from the VA, I'm not going to say what happens to it, but I'm a non-responsive guy. But if they don't ask those questions and they don't have those answers when they come to sit before us or the full committee, we're going to hold them accountable. So my question is, how do we fix that problem? And don't say pass the law, because we're not there yet. But the way we engage with the spouses is by mail. Snail mail, email. I dare not say the VA is launching out folks to go knock on doors. I don't know that for certain. I don't think that would be the case. But here's the problem. When talking with the spouses, have you, in your engagements, have they responded in a way that said, I would prefer this to happen? Or are they just okay with, like, I'm not responding? Because there's two sides to this coin.
That's true. And we do understand that the VA is contractually obligated to ask that question. And we understand that, and we agree with that. The problem is it's not consistent. So these letters come, but not every year. So oftentimes a survivor may get one every year. They may have a lapse in time between that. So they don't always know that they're coming and to expect them. But if they have remarried, we encourage survivors to proactively reach out to the VA.
Is there a
to
time
inform
frame
them.
that's more, and I don't mean for this to sound in any way disrespectful, but is there a time frame that they would appreciate? Like, hey, is the VA, hey, reach out every 5 years, or VA reach out every year? Is there, I'm trying to solve the problem where it lives right now.
It would be helpful if it was consistent. So if they're going to do it every year in a particular time frame, then the spouse knows to expect it. But we also encourage surviving spouses to reach out to the VA to inform them that they have remarried. So that, I think, is a very important part of this as well.
Okay, thank you. Mr. Tangent, I have a question Mr. Self asked me to address to you. Do you agree that VA is obtaining too many unnecessary toxic exposure-related disability compensation exams?
Chairman, I do absolutely believe that, and what we have seen is, and this is part of our written testimony that was submitted, it appears to us that it's almost become a sixth theory of entitlement, namely being the 5 ones that are under the law are direct, aggravated, secondary, presumptive, and VA negligence. In some situations, it feels like the VA is using TARA as a method of proving by a theory of service connection. And we've seen CMP exams where veterans who haven't even filed for TARA go through a TARA exam, and the box is checked, no, this is not a TARA, and none of the other 5 theories of entitlement are checked off. It goes to the RO and is then denied, and then we have to take the claim through supplemental or a higher level review or up to the board in order to get another CMP examination, a forensic examination, to have it be done the right way.
Okay, thank you. Ranking member had to step away, so I look forward to working with these issues with the department and the rest of my colleagues on the subcommittee. These bills discussed today would provide important improvements for veterans and survivors navigating the VA claims and appeals process. They would also improve access to benefits for veterans and their surviving loved ones. The written statement of our witnesses will be entered into the hearing record. I ask unanimous consent that statements for the record we have received be entered into the hearing record. Hearing no objection, so ordered. I ask unanimous consent that all members have 5 legislative days to revise extended remarks included in extraneous material. Hearing no objections, so ordered. Thank you all for attending today. I can't believe I'm here by myself.